Sir, good morning, sir. I'm the Castro Hanilin T from Section C. This subject is CLG 400. In this video, I will answer the final examination that consists of 20 questions. Revised Rules on Evidence, Rule 128, Section 1, Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Revised Rules on Evidence, Rule 128, Section 2, Scope. The rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. Revised Rules on Evidence, Rule 130, Section 1, Object as evidence. Object as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Revised Rules on Evidence, Rule 130, Section 2, Documentary Evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. Revised Rules on Evidence, Rule 130, Section 22, Testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Corroborative evidence is additional evidence of a different kind and character of tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation of similar evidence that is derived from common sources. Prima facie evidence. Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the rule in favor of the party that offers the prima facie evidence. Section 37, Dying Declaration. The declaration of dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry, as evidence of the cause of surrounding circumstances of such death. Section 44, part of this res juste. Statements made by the person while a startling occurrence is taking place or immediately prior of subsequent thereof, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res juste. So also, statements accompanying an equivocal act material to the issue and giving it as legal significance may be received as part of the res juste. Revised Rules on Evidence, Rule 132A, Section 4, Order in the Examination of an Individual Witnesses. The order in which the individual witnesses may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Cross-examination by the opponent. Revised Rules on Evidence, Rule 132A, Section 5, Direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Revised Rules on Evidence 132A, Section 6, Cross-examination, its purpose and extent that matter determination of the direct examination. The witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias, or the reverse, and to elicit all important facts being bearing upon the issue. Revised Rules on Evidence, Rule 132A, Section 7, Redirect examination, its purpose and extent. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party, calling him or her to explain or supplement his or her answers given during the cross-examination. On redirect examination, questions and matters does not dealt with during the cross-examination may be allowed by the court in its discretion. Revised Rules on Evidence, Rule 132A, Section 8, Re-cross-examination upon the conclusion of the redirect examination. The adverse party may be cross-examine the witness on matters stated his or her redirect examination and also on such matters as may be allowed by the court in discretion. Revised Rules on Evidence, Rule 132A, Section 9, Recalling Witness. After the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest of justice may require. The Judicial Affidavit Rule JAR took effect on January 1, 2013. A normal proceeding will take around 3 to 5 or even more years to be fully decided. By requiring the submission of written affidavits of witnesses through the JAR, the time for concluding a court proceeding will be shortened. The JAR thus seeks to discongest the ever-increasing caseload in the country, brought about by the high number of cases filed each day and the lengthy procedures observed. The JAR also seeks to address any lost translation in interpreting the testimony of a witness if the testimony was translated from a local language into English. There are only 2 exceptions where compromise is not admissible as an implied admission of guilt in criminal case. In quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, reckless imprudence and simple imprudence of negligence, and 2, those allowed by law to be compromised. Their usual examples are found in the Revised Penal Code, particularly Article 266D of the Revised Penal Code, the compromise that the victim agreed to marry and indeed got married to the accused is rape, or if a compromise was made before the filing of the criminal complaint. Under Rule 128, Section 4, evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. From this rule, we gather that there are 2 components of relevance. First, relevant evidence has a relation to the fact in issue. If there is a relationship between the evidence and the fact in issue, then the evidence is material. Second, relevant evidence can lead us to believe in the existence of non-existence of the fact in issue. If the evidence supports our belief that the alleged fact exists, then the evidence has probative value. Competence, in addition to relevance, admissible evidence must also be competent. Under Rule 128, Section 3, evidence is competent if it is not excluded by the law or by the law or these rules. If a piece of evidence is disqualified by the law of the rules of court, then it's not competent and will be inadmissible. Revised Rules on Evidence, Rule 132A, Section 4, Order in the Examination of an Individual Witnesses. The order in which the individual witnesses may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Cross-examination by the opponent. Section 10. Leading and misleading question. A question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except on cross-examination on preliminary matters when there is difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is not of feeble mind, or a deaf mute, of an unwilling or hostile witness, or of a witness who is an adverse party of an officer, director, or managing agent of a public or private corporation or of a partnership or association which is adverse party. A misleading question is one which assumes as true or a fact not yet testified by the witness or contrary to that which he or she has previously stated. It is not allowed. Section 4. Circumstantial evidence. When sufficient circumstantial evidence is sufficient for conviction, if there is more than one circumstance, the facts from which the inferences are derived are proven, and the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Revised Rules on Evidence, Rule 131, Section 1, Burden of Proof and Burden of Evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue. To establish a prima facie case, burden of evidence may shift from one party to the other hand in the course of the proceedings, depending on the exigencies and the case. Civil cases. Revised Rules on Evidence, Rule 133, Section 1. The preponderance of evidence. How determined in a civil cases? The party having the burden of proof must establish his or her case by a preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issue involved lies, the court may consider all the facts and circumstances of the case, the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability and the probability of their testimony, their interest or want of interest, and also their personal credibility, so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses. True, the preponderance is not necessarily with a greater number. Revised Rules on Evidence, Rule 133, Section 2, Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof excluding quality of error produces absolute certainty. Moral certainty only is required, or the degree of procedure which produces conviction is an unprejudiced mind. Administrative cases. Revised Rules on Evidence, Rule 133, Section 6, Substantial evidence. In cases filed before administrative or quasi-judicial bodies may be deemed established if it is supported by substantial evidence, or the amount of relevant evidence which is a reasonable mind might accept as adequate to justify a conclusion. Substantial evidence is the least quantum of proof required by the rules. It is applicable in administrative actions which, unlikely judicial actions, do not include conducting full-blown trials and are meant to be concluded with greater speed. An administrative body can render a decision on the basis that the evidence presented is evidence which a reasonable mind might accept adequate to justify a conclusion. This means that the evidence can make a reasonable person believe that the allegations have occurred. Revised Rules on Evidence, Rule 132, Section 19. Classes of documents for the purpose of their presentation in evidence. Documents are either public or private. The written official acts or records of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or of a foreign country. Documents acknowledged before a notary public, except last wills and testaments. Documents that are considered public documents under treaties and conventions which are enforced between the Philippines and in the country of source, and public records kept in the Philippines of private documents required by law to be entered therein. That's Revised Rules on Evidence, Rule 132, Section 20. Proof of private documents. Before any private document offered as authentic is received in evidence, its true execution and authenticity must be proved by any of the following means: by anyone who saw the document executed or written, by evidence of the genuineness of the signature or handwriting of the maker, or by other evidence showing its true execution and authenticity. Any other private document need only be identified as that which it is claimed to be. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four exceptions? Section 3. Original document must be produced. Exceptions: when the subject inquiry is the content of a document, no evidence shall be admissible other than the original document itself, except in the following cases: when the original has been lost or destroyed, or cannot be produced in court without bad faith on the part of the offerer, when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the facts sought to be established from them is only the general result of the whole, and when the original is a public record in the custody of a public officer is recorded in a public office. Section 20. Witnesses, their qualification. Except as provided in the next succeeding section, all persons who can perceive and perceiving can make their own perception to others may be witnesses. Section 3. Extrajudicial confession, not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence or corpus delicti. That's all, sir. Thank you.